Morning, may it please the court. Rosemary Wilder representing the appellant.
Morning.
The first issue on appeal is an unusual number of non-disclosures by jurors. We had 5 out of the 6 panel who failed to reveal their prior litigation history. I think I've been practicing for 30 years. I've never seen more than 3. 5 is just extraordinary to me. And granted, the information that was presented to the court was in the form not of Westlaw or docket entries. We went beyond that. We actually hired an investigator and filed 300 pages of information regarding the 6 jurors in order to get a juror interview. Even if there had only been 2 or 3 out of the 6, we think those standing alone would have been enough to get a juror interview in this case. For example, Mr. Reyes had 6 money judgments against him, 2006 to 2011. The trial was in 2014.
But
federal
none of
tax
those
lien.
were this type of case, though, were they? Weren't they all financial things and things
Right.
of
I
that
think
nature?
that the issue, and we've cited some cases, because granted, the cases are mixed when it comes to civil judgments and civil proceedings that are not exactly, for instance, an automobile accident, exactly a medical malpractice case. And we think in cases like Hillsborough Management and the Pembroke Lakes case, the idea, especially in Hillsborough Management, the idea is that even if this litigation doesn't necessarily go directly to the issue, they weren't involved in the same kind of incident that's at trial. The vast amount of litigation, especially related to Reyes, and I picked Hillsborough because in Hillsborough he had a lot of civil actions. There were 12 lawsuits and stuff like that.
But you know, one of the prongs is the diligence of counsel in trying to ferret this out. And it seems like there was a lot of effort with regard to the questioning. So it's hard to say that there wasn't diligence. I mean, it looked like there was a real effort here. But my question really is, this was a lay person that we're talking about. You had
Correct.
A lawyer on there. I'm going to go to him in a minute.
Right.
But this is the lay person you're talking about that had all these things, and they were financial. They weren't kind of related to this type of lawsuit. Do you think a lay person would understand the difference? Because there wasn't, to me, when I read this record, an effort, even though the lawyer was thorough, I don't think they explained it to a lay person that, look, this includes these other kind of cases. I can see a lay person saying, well, they're just asking me about car accidents.
Well, I think that the judge took care of that. First of all, they were asked of any lawsuits on the civil questionnaire. We've cited the Taylor case, which says the questionnaire standing alone is enough to elicit the information.
I've got a question about that questionnaire. Was the questionnaire ever made part of the record?
I believe it was. I believe we filed everything connected to
Below or on appeal? Did
you not see it? Oh. I apologize then. I thought when they filed the 300 pages that they filed the questionnaire also. We can certainly supplement that through the record. The 4 questions on our questionnaire.
I'll take you at your word that the responses were in there. I just wanted, before we get too far on that.
I would have to go back and look.
Right.
I know that I thought they were, but that doesn't mean that everything is in. But to your question, I'm sorry. To answer your question, this kind of massive amount of litigation that isn't revealed may not relate to the exact case you're trying, but as they mentioned in Hillsborough, it goes to the honesty and integrity of that particular juror. In other words, yes, he's been involved in tons of litigation that he doesn't reveal, but none of it is the same kind. Well, then the issue is, then why isn't he telling us about it? Why is he withholding all of this information?
Well, my thought, again, I don't know, is
and
because he's a layman and he thinks they're
right.
not asked. They mean car accidents. They don't mean this stuff.
Right.
I don't know.
I really don't
know.
And I think the cases point out, that's the whole purpose of a juror interview. The whole purpose of the juror interview is to ask the juror, what's the story here? It could be, and especially in this case, I think it's important, because this plaintiff argued to the jury as part of his mental anguish, the fact that he had to be dragged into court. He had to litigate. He was forced to go to trial. And all of this was the fault of the defendant. So I think Reyes is somebody who could...
But that would have come after the fact, and a lay juror being questioned in the voir dire part wouldn't know all this is going to come later. But
I'm sorry,
again, I'm
yes.
only trying to understand...
Going back to the lawsuits, The judge said, civil lawsuits, if you've been sued, if you sued, anybody suing, anything related to lawsuits.
But you let some people on the jury who did acknowledge they had some exposure to this.
Yes, and this is the other thing.
If you did that, then why is this all so problematic now?
Well, I think that, I mean, there was certainly, the plaintiff's lawyer voir dire the jury for 4.5 hours. So to say that this couldn't have come to their mind during this voir dire, I think is impossible. Now, they cited one case from the 3rd District that said, well, you have to define lawsuit. And that's all, it's just a straight statement, and the dissent didn't really agree with that.
But you cited some jurors who acknowledged they had, some sort of exposure to this, like Trombley, the juror Trombley, basically said, my father has been involved in something like this.
Didn't mention his.
Right. So, but you seated him irrespective of that. So if you seated some jurors who had exposure to this, then why is all of this other stuff such a problem now?
Oh, well, again, I think that when you have jurors that are involved in multiple accidents, like Simmons and Campui, who were involved in automobile accidents, and they're not revealing that, and along with that, they also have bankruptcies, federal liens, they have a mix and match of all of this. The whole question is that how are you going to exercise a peremptory challenge when you don't know any of this, and you don't know how it's really going to affect them?
And that's an excellent point. How are you going to exercise your peremptory challenges? And the way I think you do that is by finding out this information. So I kind of want to go back and maybe address an issue that I kind of hear you taking for granted almost, which is the voir dire process in this case. I read the entire voir dire in this case. I did not see Reyes, Trombley, Oliver, Campui, McKenzie, or Simmons being asked directly any of the points, either in the plaintiff's voir dire or defense's voir dire, that you are now asking for an interview over. And with respect to what the judge said in voir dire, as I read it, the judge did elaborate on what civil lawsuits may entail, and then ended with this, saying, the attorneys may ask you questions about this. You need to answer them truthfully.
Right.
Okay? And then away we went. So as I see it, what you're really left with is the questionnaires.
I think that
unless I'm misreading the voir dire, did I miss something in my reading of the transcript where any of those individual jurors were directly asked any of these points that, as far as the prior bankruptcy or the prior car?
No, and they did cite one, the plaintiff did cite one case where it said that in order to explain a lawsuit, you must tell the jury that it includes federal and state tax liens, money judgments, foreclosures, divorces, bankruptcies, etc. So there is one case out there that says that unless you specifically list all these things, then you're not going to find reversible error. However, I think balanced against all the cases we've cited where these very kinds of things were not revealed and the court has reversed for juror interview or new trial, I would say that the majority of cases don't require that explicit kind of request.
And this, well, but here's the thing. The case law tells us there's got to be some level of concealment. In other words, we're going to hold lawyers to do the heavy lifting, so to speak, in voir dire. How can you conceal something if you haven't been asked?
Well, that's what the cases early on, starting with Roberts, talk about. What constitutes juror concealment? And I think from Roberts, forward to De La Rosa and all the more recent cases, the answer to that question is you've been asked on your juror questionnaire.
So it's the questionnaire.
And in your initial questions, have you been in a civil lawsuit? Have you been sued? Are you a plaintiff? Are you a defendant? There's a mix and match of ways that those questions are asked, that the courts have found adequate questions to divulge this kind of information.
And if we take those questionnaires, just out of curiosity, it's been a while since I've looked at one. Are they sworn to?
I don't.
And the reason I ask is it strikes me that some of your argument almost seems like it's almost kind of rings like impeachment.
Well, if the questionnaires are not in our record, I don't know that we really want you to read from them.
I think the answer is they're not. I think that they fill out the procedure in this case, and I think in most cases, they fill out the questionnaire. The questionnaires all go to the judge, and then the judge reads through the questionnaires and asks them, you know, oh, Mr. Smith, I see that you are a mechanic, and that you've served on a jury. Were you the foreperson, da-da-da-da? And that's generally, you know, how it's handled. I don't believe they're ever sworn to. So it's not like an affidavit or something like that. I think that with this in mind, especially with 2 or 3 of the jurors, even though they may have had tax liens, bankruptcies, 3 of them did have automobile accidents, 2 of them fairly recent, there was enough to get a juror interview, at least as to half of the people who didn't have the disclosure. There's also what we consider the fundamental error in closing. The comments made denigrating the defense, accusing the defendant of trying to blow smoke, hiding the ball, not being trustworthy, telling half-truths, telling half-lies, trying to catch the plaintiff in a lie, refusing to take responsibility, kicking the plaintiff to the curb, that whole type of comment, and that there was sufficient comment of that type to require reversal on that point alone. But we also think that the effect of those comments is what led to the excessive verdict. And while the plaintiff says, well, we got less than what we asked for, the point is, I think Judge Schwartz said this one time, we all know that the plaintiff is going to ask for the moon in closing because that's their one shot to get whatever. So the fact that they may have gotten less doesn't necessarily mean it's not an excessive verdict. Excuse me. So I think that the result of the fundamental error in closing spilled over as far as the verdict. We gave the example of the past and future medical expenses. And that's basically our 3 points, and I'll reserve the rest of my time for rebuttal.
Thank you, Counsel.
See if I could find, I know I cited to the juror interview form in my brief also as to what the questions were that were relevant to this argument. But I see that I didn't have a record site that I could find right away. Perhaps the juror questionnaire was attached to either their motion to interview the jurors or them. Anyway, the only thing that was asked.
Counselor, are you Ms. Majewski?
Oh, I'm sorry, Your Honor. It's very rude of me.
Just wanted to make sure.
I know her, but...
Just jump right, that's right, Rosemary and I know each other. I'm sorry, Your Honor. Annabelle Majewski on behalf of Mr. Vickers, and may it please the court. First to address Judge Lucas's question. Yes, the only thing that the trial court said to the jurors during voir dire was, have you been in any previous litigation? If you have either been sued or have sued someone or threatened to sue or have been threatened with a lawsuit, if the attorneys ask you these kinds of questions, you must tell them about it. And then, as you said, there was 4 hours of voir dire on the plaintiff's side and very little time spent by the defendant's attorney during voir dire, and they weren't asked about any of those questions. Now, first of all...
So let me make sure I understand this, because this, again, goes to the diligence prong.
Correct.
Okay, so defendant's attorney asked not a single one of these jurors any questions about their prior litigation experience.
No, Your Honor.
Then remind me how Mr. Trombley started talking about his dad's experience. How did that come out then?
I don't remember exactly.
Well, because
but
I
yes, you're right, you did.
Because it sticks in my head after reading this huge record in this case. But so obviously some questions had to be asked of him for him to start talking about his dad's experience.
I think in my brief, I outlined, I think.
Because it's a critical point. The critical
How
point is
did
if they were never asked any questions, obviously, there was no basis for them to give this information.
About
But if
being-
we have one of them who starts talking about his dad's
Yeah.
experience, somebody asked him a question.
And
I would think.
I don't remember what the question was.
Okay.
I did outline every single question and answer of these 6 jurors,
Okay.
especially these 5, in my brief.
Okay.
But off the top of my head, I don't remember exactly how Mr. Trombley's answer came about. I will point out that Mr. Reyes, all of the misconduct of Mr. Reyes, or the non-disclosures, were all had to do with the money judgment, which could have been that he didn't pay his credit card and they sued him and he just, blew it off, and they got a judgment against him for whatever his outstanding balance was. That's not really material to a rear-end collision with injuries. With Mr. Twombly, his father's accident may be material, but we don't know when it happened, how long ago it was. Mr. Twombly, being an attorney who has also said he can be fair and impartial, I don't think it's grounds for a new trial based on juror misconduct of Mr. Twombly. With Ms. Campui and Ms. Simmons, once again, they have money judgments, which are not material and also remote in time. And the only thing with them is perhaps they were involved in accidents, and that perhaps people were injured, and perhaps Ms. Campui or Ms. Simmons were injured in any accidents that they had. I'd like to point out to the court that just because you're in an accident doesn't mean that you were injured, or even if you were at fault, that you were involved in a lawsuit. Usually when we have a fender bender or even a rear-end collision, you call your insurance company, they take care of it, and more than likely you never hear from it again. There's no lawsuit involved. I must confess that I've rear-ended somebody twice, and Geico took care of it. I had no lawsuit, no nothing. So if you asked me, have I ever been involved in a lawsuit, my answer would be no.
Well, let me ask you a question as far as the due diligence prong. What do the cases say about counsel being able to rely on the answers given on the juror questionnaire?
I don't see that any of the cases either one of us has cited really addressed the juror questionnaire. It was basically, what questions did you ask the venere that should have elicited the prior litigation history?
Because one of the things that concerns me is the juror questionnaire asks what it asks, and part of it is replicated in the briefs. And then the judge gives a further explanation as to what is meant by civil litigation, and he goes beyond that as well, not just describing the litigation. And it's clear that counsel, I think on both sides, were exploring information that was disclosed on the juror questionnaire. But I don't recall if anyone said, okay, now that you've heard all this discussion, you've heard what the judge said, is there anything else that you would disclose or like to talk about? Was a broad question like that ever asked?
I think that there was I think not necessarily to everyone. I think there was at least one person, but can't recall that it was any of these particular people, where it was, is there anything else you want to tell me about that?
I believe there were at least a couple of times questions that were asked along the lines of, is there anything that would prevent you from being fair, being impartial, but nothing that seemed to tie back into the juror questionnaire or what the judge explained?
No. And yes, plaintiff's counsel did ask on several occasions almost to every person that he interviewed. He ended the questioning with, is there anything that would keep you from being fair and impartial? And there really isn't anything that would keep them from being fair and impartial. As I said, saying that possibly someone was injured in an accident and possibly they might have been prejudiced sounds more like the fishing expedition that and that's why juror interviews are usually frowned upon and discouraged. And I would say that it is an abuse of discretion standard, and so it was the judge who was there and had the ability to see whether these jurors were being fair and impartial, and that's also reflected in the jury verdict. The other thing is they also sought a new trial based on the excessive verdict, and in that case, it was the defendants had already agreed that the past medical expenses were reasonable, and so their main thing was in bringing Dr. Shulak to show that the injuries were not related to the accident. And the jury just didn't buy Dr. Shulak's testimony, and that doesn't mean that the verdict is excessive, and especially since there is evidence to prove all of the damages and the monetary figures, and then the jury did not go for the plaintiff's request. They made their own decision as to what they thought would be a fair award of damages. And as to the remarks of plaintiff's attorney in closing argument, the one remark about being kicked to the curb, that was objected to. The objection was sustained, and that was the end of it. Defense counsel didn't ask for a curative instruction and did not move for a mistrial. So they did not preserve that as an error. And the other objection, I think there was some question about plaintiff's counsel said something about they're hiding something. He was referring to Dr. Shulak because he had already elicited testimony that Dr. Shulak had not looked at all of the plaintiff's medical records. He was pick and choose as to how he formed his opinion. And so plaintiff's counsel was bringing out the fact that Dr. Shulak had omitted parts of the record and was not presenting the entire medical history and the entire medical records at his disposal to the jury in forming his opinion.
Counsel, very, very quickly, can you walk me through, you raised the argument that there was a procedural impropriety in the motion itself under Rule 1.431H, and you make the argument that, at least as I read the argument, that that's basically dispositive. Can you just briefly walk me through that argument?
Yes, the fact is that they mention the people, but in their motion for juror interview, they don't really give the adequate amount of information so that the plaintiff can then go and find out, are these really the people that you claim were involved in these money judgments or these automobile accidents? Is it the same Mr. Robert Ray is it the same Patricia Simmons? Some of them have unusual names.
If we had 4 John Smiths on the veneer panel, I could see that. But can you walk me through the legal argument? Maybe not necessarily why the rule is there, but why you believe that the rule should be applied in the way that you're arguing, at least in your brief.
I'm sorry, Your Honor. I didn't study up on that one,
okay.
And so I can't give you an answer. I would have to rely on my brief on that one. Are there any more questions?
Thank you, counsel.
Thank you, Your Honors. I'll get out of your way.
Okay. Defense counsel did ask the questions at the record at 162 to 169. Have you ever been involved in a lawsuit? Have you been sued? Involved in claims of litigation? They asked Tromley. He's discussing your lawyer, involved with lawsuits. So clearly the type of questions that are normally asked were asked.
Was the veneer panel generally, or was that asked to a specific?
He was asking individual jurors. Have you been, he was responding
Which
to the
ones?
answers. Okay, Okay, Pearson, let's see, juror 15, I think was Campani. Juror 16,
That was not, juror 16 was not one
that's
of the
a
jurors.
22, 18, 22, 24.
Okay, so only
Were all
Capani,
individually asked. Now, of course,
but only Capani was a seated juror.
let me see what number she was, hang on.
She's 15,
15.
at least
yes.
according to the briefs.
15, Simmons was 19. So what he did was, the plaintiff had already spent 4 hours talking to them about lawsuits, litigation, personal injuries, claims, et cetera. They had the answers from the questionnaire. And he just went back with several of these to follow up on lawsuits if he wasn't clear about what they had answered. So additional questions regarding lawsuits and claims was asked by defense counsel, and I think it's at 169, he says, and do you have anything else you need to tell us? The judge already had instructed them to say anything that might affect them being fair. Clearly, they all thought they could be fair or said they could be fair, but that doesn't always show the truth of the matter, which is, of course, the entire issue. Regarding the rule, their complaint was there wasn't an affidavit filed with the motion, and we cited Cheney.
I didn't quite read that because I don't think the rule necessarily, I'm not sure, I don't have it in front of me, I'm not sure the rule requires an affidavit, but.
No, it doesn't, but that was from what I
But it does
understand.
require, the rule does expressly require ID the juror by name and give an address.
Yes,
And
and
there was
so
at
what we
least
did
some,
is-
there was at least some procedural impropriety. I get your
Right.
argument that we attached the investigative report, which
Right.
buried in there has got their
Well,
address.
no, the investigative report only went to the 5 jurors.
Mhm.
And they were not, and
That doesn't-
honestly, why our defense counsel did this, we actually got in a fight about it. I told him to
I
meet
don't
me,
need to hear about fights,
but we did attach their identification, plus, truly and honestly, of course they know who they are. They picked these 6 people, they've got their names, they know what those initials stand for. They knew Robert Reyes was one of them, and Simmons was one, and Capani was one. So to say that just because you used initials in your motion violates the rule, I
well, I mean, I guess that, if you were to be persnickety, the point would be, you didn't identify them by name, you didn't put the address in the motion, which the
Right.
rule says you shall do it.
So
We're left with, what is the effect
filed
of
it.
that?
Yeah, we didn't put it in the motion, but we made it in our 300-page attachment to the motion, filed with the motion. But it was not technically in our motion, and honestly, that's an interesting question, because I've done this a lot. I don't know that I've seen addresses, but we'll pay attention to that from now on. At any rate, I think,
Do any of the cases explain what level of reliance counsel can give to the juror questionnaire?
that's the Taylor versus Magnata case, and it absolutely says, and we've quoted it, this is Taylor, Magana, it's in our reply brief, 9/11, 7/2, 1263, and it says, if we were to accept the trial judge's rationale, in this case they had denied the motion for juror entry, then a pre-printed juror questionnaire, which a trial judge uses to conduct the initial portions of the jury selection process, would be useless and a total waste of judicial effort, unless the trial judge requires each prospective juror to answer each question specifically line by line to eliminate any possibility of ambiguity. Additionally, no trial lawyer could run the risk of failing to re-ask each and every question on the pre-printed questionnaire for fear of failing to exercise due diligence. Taylor says the questionnaire is enough, and when you don't answer the questionnaire, that is a sufficient basis, at least for a motion for juror interview. And that's really what we're saying, that all things combined, all things considered, at the very least, we were entitled to a juror interview.
Very good, thank you, counsel. The next case on the docket is Maroney versus Allen. For counsel, that will be here on the Neapolitan versus City of Naples case, the 5th case on the docket. We will take a short break before we do that case.